So Courtney and Nicole Mallory, they were charged with 3 different charges in Colorado. CRS 183602-1C, which is a charge of stalking. CRS 184506.5, tampering with a utility meter. It's a Class 2 misdemeanor, and CRS 18441, theft under $50. It's a petty offense. And even though it's a petty offense, it's a Class 1 petty offense. So, I mean, there's only 2, and I think it's just the second one is whatever is suggested the punishment is. But the Class 1 petty offense, the maximum punishment for a petty offense in Colorado, which is under misdemeanors, is 6 months in jail and $500 fine. So there's still no joke. 6 months in jail, $500. Theft under $50 also petty offense. You know, I mean, 6 months, $500. It's like, I don't know. Well, he only stole a $20 thing, so that's not. But it is kind of like that, isn't it? So, okay, 184401. Basically, that's just thou shalt not steal. Thou shalt not steal. In Colorado, you're not allowed to steal. You're also not allowed to run a house of child prostitution. So you motherfuckers don't try to do that. 184506.5, tampering with the utility meter. Yeah, don't run a house of child prostitution. Don't y'all fucking do that. Especially right-wing fucking pervert motherfuckers. You oppressor, molester, motherfucking pieces of shit. Learn to keep your goddamn hands to yourself, you fucking pieces. Tampering with the utility meter. 184506.5, tampering with the utility meter. So, let's just go ahead and read it. 1. Any person who connects any pipe, tube, stopcock, wire, cord, socket, motor, or other instrument or contrivance with any main service pipe or other medium conducting or supplying gas, water, or electricity to any building without the knowledge and consent of the person supplying such gas, water, or electricity commits a Class 2 misdemeanor. Any person who in any manner alters, obstructs, or interferes with the action of any meter provided for measuring or registering the quantity of gas, water, or electricity passing through said meter without the knowledge and consent of the person owning said meter commits a Class 2 misdemeanor. Number 3, nothing in this section shall be construed to apply to any licensed electrical or plumbing contractor while performing usual and ordinary services in accordance with recognized customs and standards. So that's 18.4. Now that was apparently, they had camera was on the post. The camera and a motion detector was up on the post. And I don't know if they just connected it straight to the utility pole or what had happened. So now we have what? Thou shalt not steal. I might not have marked it. Might thinking it was just so bland and regular. No, here it is. Thou shalt not steal. Theft. A Class 1 petty offense if the value of the thing involved is less than $50. Theft. The person commits theft when he or she knowingly obtains, retains, or exercises control over anything of value of another without authorization or by threat or deception, or receives, loans money by pawn or pledge on, or disposes of anything of value or belonging to another that he or she knows or believes to have been stolen, and A, intends to deprive the other person permanently of the use or benefit of the thing of value. B, knowingly uses, conceals, or abandons the thing of value in such manner as to deprive the other person permanently of its use or benefit. C, uses, conceals, or abandons the thing of value, intending that such use, concealment, or abandonment will deprive the other person permanently of its use or benefit. Demands any consideration. D, demands any consideration to which he or she is not legally entitled as a condition of restoring the thing of value to the other person. All right, I'll give you your thing back, but you got to give me $20. Knowingly retains the thing of value more than 72 hours after the agreed upon time of return in any lease or hire agreement. That's interesting. So if you borrow a ladder, you should make sure you return it tomorrow. And if they don't return it tomorrow, then that's theft, right? And then that's a class 1 petty offense if it's under $50. A class 3 misdemeanor is if it's between 50 and 100. And then class 2, class 1, they keeps going up 2 to 5,000, 5 to 20. Up to more than $1 million, a class 2 felony if the value of the thing involved is $1 million or more. So if it's more than $1 million, that's a class 2 felony. 3 and 3.1 has been repealed. 4A, when a person commits theft twice or more within a period of 6 months, 2 or more of the thefts may be aggravated and charged in a single count, in which event the theft so aggravated and charged shall... Alright, so that one's actually pretty easy. Theft, right? Thou shalt not steal. That one was about the garbage can. So it's Nicole and Courtney Mallory, who, you know, the two black cowboys, the two black ranchers, husband and wife. You know, just trying to run their ranch up in El Paso County, and you got all those fucking racist pieces of shit. So the theft is, apparently he took a garbage can. And a garbage can, they're saying, is under $50, but they said that that garbage can was not his. He took a garbage can, Courtney did, that was not his. So that's interesting. I mean, I don't know. Apparently they got it on videotape, and I would like to hear what his explanation would be. And then the last charge is stalking. This is Vonnie's Law, 183602. Vonnie's Law, 183602. Not only is this a whole fucking page, but then the annotation goes on and on. So this is kind of a complicated law. Just some of the titles of the annotation. Serious emotional distress was supported by the evidence, where the victim testified that she suspected the defendant was stalking for her over a month. Evidence sufficient to support a finding beyond a reasonable doubt of serious emotional distress, where the victim testified that the defendant's behavior caused her to change her work schedule, take days off from work, and feel unsafe. Evidence sufficient to establish a credible threat. The credible threat does not need to be separate from the harassing behavior or verbal. Therefore, evidence that the defendant was only at the victim's place of employment when the victim was there. The defendant would approach and make eye contact with the victim, and the defendant found out where the victim went to church and attended that church, was sufficient to establish a credible threat. People v. Cross. Colo Appeal 2004. People v. Cross. People v. Sullivan. People v. Suazo. People v. Suazo. Colorado Appeals 2003. People v. Sullivan. Colorado Appeals 2002. People v. Cross. Evidence sufficient to establish that emails with their implicit and explicit threats would have caused a reasonable person in recipient's position to feel fear for their safety and the safety of others. People v. Chase. People v. Chase 2013 COA. Is that the Court of Appeals? COA 2013. So let's just read some of this. 183602. Stalking. A person commits stalking if directly or indirectly through another person. The person knowingly A. makes a credible threat to another person, and in connection with the threat repeatedly follows, approaches, contacts, or places under surveillance that person, a member of that person's immediate family, or someone with whom that person has or has had a continuing relationship. Or B. makes a credible threat. Or, okay, so any one of these, right? If you make a credible threat to another person in connection with the threat, and in connection with the threat repeatedly makes any form of communication with that person, a member of that person's immediate family, or someone with whom that person has or has had a continuing relationship, regardless of whether a conversation ensues. Or C, and this is what Courtney Mallory has been charged with. This is also a class 5 felony. This is the big fucking charge, okay? You know, he probably could just accept the, the misdemeanor, class 2 misdemeanor petty offense, get some sort of slap on the wrist, pay some tiny fine or some shit. Tampering with the utility meter, I don't know what the explanation would be for that. They said there was some wire. A part of me thinks that the cops are taking the video camera down because they don't want the Mallorys to get evidence. They just want to get evidence on the Mallorys, but the Mallorys, it's kind of like when you go into court and it's all about videotaping the evidence, right? But for some reason, only the court can videotape you and audio tape you and, transcribe you, but you can't. It's just hypocrisy. It's just hypocrisy. So if they were sitting there investigating the Mallorys and then they saw that the Mallorys were investigating them, well, That's a possibility, right? Just take their video cameras. They had 3 video cameras. Now, that it's tampering with the utility meter, so it's making me think that they tied the video cameras to the utility meter. I don't know. I mean, it's good that they even have electricity where they're at. I don't have electricity where I'm at, so utility meter, what the heck? But if they did tamper with the utility meter, then that would be, clear as day or not clear as day. Is there just a plug? Can you just plug into the damn utility meter? Also, you got to get charged for that. So I guess, and then it was motion detector. So it wasn't like they're trying to say also that the video camera, the surveillance, was somehow tied with the stalking. The stalking is like a couple of other things too. I'm gonna read the arrest warrant. The affidavit for the arrest warrant that Earhart, or that fucking guy Gerhardt had wrote out the arrest warrant and what he had thought. So it wasn't just the video camera. I thought that was kind of stupid. What, just the video camera? They're stalking me. Why they put? I think you're allowed to stand on your porch and just fucking videotape out your front door, off to the side and to the right. Now, if they say it's just fixated in one spot, that's not how a video camera works. It's, it's not a total panorama, but it's at least a 45-degree angle. So I guess you could say like it's centered right in the middle, but even if it's centered right in the middle, like right in front of me, I would, center it frontwards so you could see that corner and that corner. So you would actually see the whole thing. Not because, there's a person straight in front of me, but if there is a person that's straight in front of me, because, people have neighbors that's right across the street from them. So if the person is, I can't put a videotape because there's a house on that side, bullshit. Here's how I think about freedom in America. Outside your house, I can, videotape whatever I can videotape. If I'm up in the balcony, even if I'm inside my house, out the window. If I'm in my yard, I can videotape anything and everything that's out and about here. Now, what I'm not allowed to do is videotape inside your house. You got to put the curtains, you got to cover up this and that, but I can't go inside your house. And if there's, windows, you got to cover those windows up. But if your abode is completely covered up, there should be no possible way of videotaping you. And so, don't go walking by your windows, mooning everybody. So I can see how they can say they're infringing on our, right at the bedroom window. They was doing the video right at the window. Motherfuckers, why don't you get a video camera? Everybody get video cameras. That way everybody knows what the truth is. You can't argue with the video camera. You put a video camera up, I put a video camera up. Do you realize all the shit that happened to the Mallorys? They had somebody was fucking murdered. The pig and the goat and the dog they were gutted or poisoned, antifreeze, some shit. Motherfuckers just showing up on their goddamn property and shit. People went inside their house and they wrote N-words on everything. Just wrote the N-word. I don't know if they spray painted or just wrote it with a pen. They said that they vandalized their cattle. So did they spray paint the cattle too? So it's a class 5 felony. He's looking at a class 5 felony, which is a maximum of $100,000 or 3 years in jail. And they're trying to take his gun rights away, and which means they're trying to take his citizenship away. So it's makes sense for them to fight back and be, a little freaked out about this. So, the Karen Act. We should definitely pass the Karen Act. I saw them do a little thing at the Denver. Repeatedly follows. So, here's what stalking. This is what they are accusing Courtney Mallory. And they have elements, right? All these, there's elements. So, whatever Courtney Mallory was doing, they're going to have to sit there and say that each and every one of these elements, matches. So a person commits stalking if directly or indirectly through another person, the person knowingly, C, repeatedly follows, approaches, contacts, places under surveillance, or makes any form of communication with another person, a member of that person's immediate family, or someone with whom that person has or has had a continuing relationship in a manner that would cause a reasonable person to suffer serious emotional distress, does cause that person, a member of that person's immediate family, or someone with whom that person has or has had a continuing relationship to suffer serious emotional distress for purposes of this paragraph C, A victim need not show that he or she received professional treatment or counseling to show that he or she suffered serious emotional distress. Need not show. I've had serious emotional distress. How do we know that? I just gotta take my word for it. Repeatedly follows, approaches, contacts, places under surveillance, or makes any form of communication with another person, a meeting. So there's a lot of things going on there. For the purpose of this part 6A, conduct in connection with a credible threat means acts that further advance, promote, or have a continuity of purpose and may occur before, during, or after the credible threat. B, credible threat means a threat, physical action, or repeated conduct that would cause a reasonable person to be in fear for the person's safety or the safety of his or her immediate family or of someone with whom the person has or has had a continuing relationship. The threat need not be directly expressed if the totality of the conduct would cause a reasonable person such fear. C, immediate family includes the person's spouse and the person's parent, grandparent, sibling, or child. D, repeated or repeatedly means on more than one occasion. 3, a person who commits stalking. A, commits a class 5 felony for a first offense, except as otherwise provided in subsection 5 of this section, or B, commits a class 4 felony. Stalking is an extraordinary risk crime if at the time of the offense there is a temporary or permanent protection order, injunction, condition of bond. Class 4 felony. Nothing in this section shall be construed to alter or diminish the inherent authority of the court to enforce its orders. Civil criminal contempt. A peace officer shall have the duty to respond as soon as reasonably possible to a report of stalking and to cooperate with the alleged victim in investigating the report. When a person is arrested for an alleged violation of this section, the fixing of bail for the crime of stalking shall be done in accordance with section 16.4.1054. CRS and a protection order shall issue in accordance with section 18.1.1015. This subsection 8 shall be known and may be cited as Vonnie's law when a violation under this section is committed in connection with the violation of a court order, including but not limited to any protection order or any order that sets forth the conditions of a bond. Any sentences imposed pursuant to this section and pursuant to section 18.6.803.5 or any sentence imposed in a contempt proceeding for violation of the court order shall be served consecutively and not concurrently. Consecutively and not concurrently. So maybe we'll talk about the annotation. A person commits the offense of stalking if he or she knowingly engages in conduct that causes a reasonable person to fear for his or her safety or the safety of his or her family or intimates. People v. Chase, 2013 COA. Hey, wait a second. Yeah, that's what that Phil Greeny was doing. That Phil Greeny was stalking the fucking living shit. So was goddamn motherfucking Robert Pickerel, Phil Greeny, and who else was with them motherfuckers? Just stalking the shit out of me. They're like, we're not going to let you get a job. Nope, we're not going to let you go get a job or go to the grocery store. Nope. You're not going to go find a wife. You're not going to live your life. That's what Phil Greeny and motherfucking Robert Pickerel is all about. That's all they were about. And Jacqueline fucking Mitchell, fucking shit. For 2 fucking years, there nothing but piles of fucking shit on top of piles of fucking shit. You know, let's 2023, the word of the day should be reassurance. Reassurance. Oh, I know you're shitty. Oh my God, do I know you're motherfucking shitty. Can you reassure me that you're not going to be shitty? I dare you. I dare you. Can you even fucking do it? Reassure others that you're not going to be a shitty motherfucking piece of shit. Can you even do it? Huh? Reassurance. I'm not going to hurt you. If I can't help you, I'm not going to hurt you. When my cup overfloweth, I'll, help you more. But I'm not going to bother you. I'm not going to harm you. I'm not going to hurt you. I can reassure you. Coming up next, John Adams and, check us out, Reverend Elisha W. Green. It's from Maysville.